Hello and welcome. This video, Funding a Revocable Trust, is the fourth in a series of 10 videos designed to educate Utah residents about estate planning. For a list of all of our videos, see below or return to our website. In this video, we will answer the following questions. Why is it important to place my assets in my revocable trust during my lifetime? How do I put real estate that I own into my revocable trust? How do I put bank and brokerage accounts into my revocable trust? How do I put other assets into my revocable trust? What is a pour-over will? And what is a power of attorney? For more detailed information, you can visit our website at utahtrustsandestates.com. As described in video number 2 of this series, a revocable trust, also sometimes known as a living trust, offers two potential benefits. One, it avoids the need for a court-supervised probate upon death. And two, it avoids the need for a court-supervised conservatorship in the event of incapacity. However, a revocable trust provides these benefits only with respect to assets that are held in the revocable trust at the time of incapacity or death. As a general principle, an asset is held in a revocable trust if, and only if, title to the asset is held in the name of the trustee in his or her fiduciary capacity. Once you sign a revocable trust, you should therefore immediately transfer your property to the trust. If you acquire real estate or open new bank or brokerage accounts after the revocable trust is created, title to that newly acquired property should also be taken by you in your capacity as the trustee of the trust, not in your individual capacity. In order to fund a piece of real property into a revocable trust, a deed is signed transferring the property to the trustee of the trust. For example, to William and Mary Jones, trustees of the Jones Family Revocable Trust. And the deed is then recorded in the recorder's office of the county in which the real estate is located. In order to place a bank account or a brokerage account in a revocable trust, title to the account, that is, the name that appears on the account, is placed in the name of the trustees. Again, William and Mary Jones, trustees of the Jones Family Revocable Trust. When an account is put in the name of the trust, banks and brokerage firms will usually ask to see a copy of the trust. However, many people are reluctant to disclose to the financial institution the confidential contents of the trust. In response to this concern, the Utah Probate Code provides that in lieu of a copy of the trust, the institution must accept a trust certification that states certain basic information, such as the name of the trust, the date the trust was created, the name of the creator of the trust, and the name and address of the trustee. Assets that do not lend themselves to formal title, such as jewelry, furniture, and other tangible personal property, can be transferred to a revocable trust through a general assignment, or a similar document signed by the creator of the trust. This general assignment is signed at the same time the trust is signed. Some assets may not be transferred to a revocable trust. For example, federal law prohibits any person other than the plan participant, that is, the employee, from owning his or her retirement plan. Consequently, your retirement plan cannot be transferred to the trustee of your revocable trust, even if you serve as trustee of that revocable trust. But then, there is no need for a retirement plan to be held in a revocable trust, because the retirement plan will avoid probate in any event by virtue of the beneficiary designation that is attached to the plan. A pour-over will should always accompany a revocable trust. Many people who create revocable trusts neglect to transfer all of their property to their revocable trust. And often, when they acquire new property, they neglect to take title in their names as trustees of their revocable trusts. The result is that they die owning property in their names as individuals rather than in their revocable trusts. Property that is held in the revocable trust will successfully avoid probate, but property that is not held in the revocable trust must pass through probate unless it is held in joint tenancy or has a valid beneficiary designation, which I do not recommend for reasons described in video number 7 of this series. At the end of the probate process, the executor of the estate must distribute the probated property somewhere. All of the provisions of the deceased person's estate plan that explain who is supposed to get what property are contained in the revocable trust. So what is needed is a simple will that directs any property that must pass through probate into the revocable trust. That is what a pour-over will does. It pours over into the revocable trust any property that must pass through probate because the decedent neglected to put the property in the revocable trust while she was alive. The pour-over will just puts the property into the revocable trust where it should have been in the first place, but it does so only after an unnecessary probate. If a person becomes incapacitated, someone will be needed to manage her financial affairs. If she has a revocable trust in place, the successor trustee of her revocable trust will immediately start to manage the assets in the trust. No court involvement will be needed. But what happens if not all of the incapacitated person's assets have been transferred to the revocable trust? The successor trustee of the revocable trust will not have the authority to manage assets that are not held in the trust. In that case, if the person has a financial power of attorney in place, the person's agent under the power of attorney will have the authority to manage the assets that are not held in the trust. In many cases, the agent will be given the authority to transfer those assets to the trust. But without a power of attorney, assets not held in the revocable trust will be subject to a court-supervised conservatorship, which, as mentioned earlier, is an expensive and burdensome process. That concludes this video. I hope you have found it helpful. For more information on this topic, you can visit our website at utahtrustsandestates.com or call us at the number you see on your screen. If you would like to watch another video in this series, either click on the appropriate link below or return to our website. Thank you.